Hello and welcome, everyone. I'm David MacArthur. I'm a co-chair of KCAB Next. I and my fellow co-chair, Robert Wachter, along with Sue Hyun Lim, is the Secretary General of the KCAB International, have organized this event, and we want to get it rolling. The first thing that I want to do is to check the attendees and whether we have people registered. So I'm going to ask my assistant at the KCAB, Amy, to let me know what our signups look like, if people are still logging in. We might just give it a few minutes.
The number was going up as you were speaking, David, slowly. It's paused at 93 right now. Now it jumped up to 95. So I think that we have a good number that we could probably start, but people will probably keep dialing in.
Good. And we have, I think we have a quorum, and we can begin. So as I said, I'm David MacArthur at BKL, and I'm a co-chair of the KCAB Next, which is organizing this event. I will say a few remarks, and then I will turn time over to my fellow co-chair and to Sue to make some additional remarks. So I'll begin. Welcome, everyone. On behalf of KCAB Next, welcome to Testing Out Virtual Arbitration in Real Life, in which we will conduct a mock arbitration hearing before your very eyes via the Zoom app in real time with a tribunal decision at the end. As you can see, it's a beautiful spring day here in Zoom land. One of the many functions of Zoom is that you can set a virtual background, which you can use to create the proper atmosphere. You can maintain privacy in your spatial privacy and set the right atmosphere for a meeting. It's one of a number of functions of the Zoom software that we're going to try to highlight and show for you today. Briefly, let me just mention how this event came about. In view of the COVID-19 illness, virus, which is spreading around the world and creating a lot of social disruption. We are social distancing. Some of us are working from home. Most of us have restrictions on travel and on large gatherings. For those of us engaged in arbitration, this creates an obstacle to conducting proceedings. It's not only in arbitration, it's in legal services generally and business in generally, and all of us are forced to do more of our work online. With arbitration hearings, this creates quite a difficulty because traditionally we do these things in person and we find great value in having hearings in person. Not having the option to do that currently, a lot of hearings are being canceled or delayed and rescheduled, but we don't know until when. It is uncertain when things are going to normalize again and we're going to be able to gather. So, well, justice delayed is justice denied, as they say, and parties are now looking toward alternatives that might help them achieve resolution sooner rather than try to wait out the virus. One of the ways that they're doing that is to consider online hearings. I know that my team is now engaged in a debate about whether an upcoming hearing is going to be held online or not. I know I hear the same story from many others. On the other hand, none of us are really well familiar with these kinds of technologies, although we may use Skype or something similar from time to time, Microsoft Teams, others, but to use it in a formal setting where there's procedures involved and multiple participants dialing in, it's a bit more complicated. And we thought that, gosh, it's not only us, but everybody in the community who's going to be encountering this predicament. and having to put together meetings of various sorts and various numbers of people on fairly short order and without the assistance of professionals who handle these sorts of webinars. So here we are. We put it together. Those of us who, again, without a lot of experience to go into it and handling the technological tools, and we thought, gosh, rather than do a polished one and have a professional service, it would be more instructive and useful to many others to see the process work, where we're just kind of trying to make the best use of the tools and learn as we go along. So with that said, we thought it would be a useful exercise to hold this mock hearing in this manner. As a result, I cannot guarantee that there would not be any technological difficulties, but these things also come up in real life. Many of us have experienced those things in the past, and we need to learn to be in command of the technological tools. So with that, I will now turn the microphone over to my fellow co-chair of KCAB Next, Robert Wachter, who will briefly explain the content of the mock hearing as well as explain the nature of the Q&A and the discussion that will follow. Robert.
Thank you, David. Just for everybody's benefit, the planning for this event came together very, very quickly. The problem, we figured out that we needed a problem for this procedural hearing. That came together on the back of a napkin. The idea was that if we had more time, we would have set this up so that we would have had the letter from the tribunal, the initial letter to the parties, saying, you know, we invite you to confer and to try to reach agreement on procedural issues and report back to us on what you can agree or not agree on. And the idea was to have one page jointly from the parties identifying those issues that they could agree or not agree on, and that would be the agenda. But we didn't even really have time to do that, to finalize it. We came up with a list of procedural issues that are frequently argued in international arbitration. I think the initial list had like 7 or 8 or 9 issues, and we were worried that we would go on too long. That's not really the point of this exercise. It's to really test the technology. So the 2 council teams decided to narrow that world of issues down. They're going to be arguing about the governing law in the arbitration. They're going to be arguing about the suitability of video conferencing for a hearing, not just a procedural video conference, but an actual hearing where there would be witnesses. There's going to be a dispute about bifurcation and the IBA rules. And you don't, those who are dialing in, you don't really need to see that, but you just should be aware that there is a universe of facts that both of the council and the tribunal have agreed on. But we didn't think that you needed that to appreciate the marvelous oral advocacy that you're about to hear from the council and the wise and insightful questions from the tribunal and their good decision making from our esteemed tribunal. During the course of the webinar, if you have any questions, we're going to have a Q&A, maybe some comments at the end. Feel free to submit written questions, or maybe you'll be able to ask some questions at the very end. And with that, I would like to ask Sue to make a few remarks and to introduce the tribunal and the council teams.
All right, thank you, Robert, for that. Hello, everyone. Thanks so much for joining us. I'd like to first start to say that despite these times, the predominant mood I am in is thankfulness. Thankfulness that some parts of our lives are being carried out as normal. And I feel immense gratitude for the people who have suggested this webinar and helped us prepare with it. Of course, David and Robert as co-chairs, they're also been involved. One of our mock tribunal members, Thomas Walsh, who first proposed this, he was also very helpful. And of course, all the other participants that are helping us do the mock CMC. Also, great thanks to all our friends all over the world that are joining us. The last I heard, there are about 130 some people logged in from different parts of the world. Welcome all, and thank you so much for being with us. Without further ado, I'll just run down the people who are participating and will be acting out the mock CMC. For the tribunal, we have three very, very competent friends of KCAB who will be acting as the tribunal members. First, we have Chiann from Hong Kong. She'll be acting as the president of the tribunal. Hello, Chiann. And we have Professor Joongi Kim, based in Seoul, who will be another member of the tribunal. And of course, Tom Walsh, who first had the idea of having the case management conference. He will also be acting as a third, the panelist, or sorry, the tribunal member. For the council, I think we had a very short run through, or we were supposed to have a little run through of the case itself, but the mock case involves two parties. One party, imaginary party based in Korea, which we call K company, and the respondent is an imaginary company. For some odd reason, we just decided they're based in Austria, and we'll call it the A company. So claimants, the K company's counsel will be acted out by Mr. Sanghoon Han and Hyunyang who are now working in Lee & Co. Thank you very much, Sanghoon and Hyunyang, for being the counsel for the claimants. And for the respondent, A company, we have Junu Kim and Hyunjung Lee, both working now at Baker & Lee, who will act as the counsel for respondent. Thank you, Junu and Hyunjung. It's so good to have you. So I think I've introduced the panels, and as Robert mentioned, we will have a Q&A session at the end of the session. You may submit your questions either by using that tab on top of the screen, the Q&A tab. You can either submit your written questions, or I think you can do this little wavy little thing. You can press on wave next to your name, and Amy from KCAB will see you and will give you the mic. So that will be another way of submitting questions. After the session, me and Robert and David will be back to coordinate the Q&A session. And yeah, hopefully this will be a lively and fun discussion. So with that, I think we'll leave it to the tribunal members.
If I may, I just want to quickly clarify, during the course of the mock hearing, as Sue mentioned, if you do have a question during the hearing, the way to submit that is to find the Q&A option. Maybe it's at the top, maybe it's at the bottom. Click on that and you can submit your question in writing during the course, and then we'll take those questions and try to answer them at the end in the Q&A session. During the Q&A session, there may be an option where you can click a hand wave, or there's an option to raise your hand if you want to ask your question orally, and we will try to facilitate that.
Thank you, David and Sue. The tribunal thanks the parties for their efforts in organizing this virtual procedural conference. You will know the tribunal members, and Sue, of course, has introduced them, but for the sake of good order, I'd like to introduce my colleagues. At the top of the screen next to me is Mr. Thomas Walsh, who is the claimant's appointed arbitrator. And then we also have Professor Joongi Kim, who is also represented on the screen above and is the respondent's appointed arbitrator. We have already had several exchanges in relation to the procedural issues, so I don't need to reiterate every point at this point, but I do wish to put on record the parties' confirmation that you have indeed agreed that this hearing shall proceed virtually. Can I please invite the parties to confirm that they still agree to this? For the claimant, can you please confirm?
Yes, thank you, Mr. Arbitrator. We can confirm that this hearing can proceed virtually. Thank you.
Thank you, Mr. Han. And for respondent, can you please confirm?
Respondent confirms.
Thank you very much, Mr. Lee. So now before the claimant begins with its arguments, I would like to lay down a few ground rules for this virtual hearing. First, in relation to the use of technology. Please leave your electronic devices away from the device that you are using for this video conference procedural conference. This will limit the obstruction or the instability of our connection. Secondly, please remain on mute when others are speaking. You can press the mute button or double click when your space bar. As you know, there is also a recording function in the Zoom program. We have discussed issues of confidentiality in preparing for this procedural conference, but please be reminded not to record the session. We have a transcriber on screen for this purpose. And finally, the tribunal appreciates both parties' cooperation on any technical matters that might arise during this virtual hearing. If we do need to pause at any point due to technical issues, the tribunal will bear this in mind in terms of ensuring the parties' opportunity to present their case. The second point I'd like to raise is in relation to signals. Whenever you wish to speak, instead of interrupting, please raise your hand. I will be mindful of all of the screens and acknowledge your hand and invite you to speak after the speaker has finished. And finally, in relation to speaking cues, I will endeavor to lead this procedural hearing and will clearly signal when appropriate time is for each party to speak. And please do wait until then. And please again, and I will reiterate this several times, I'm sure, because it is natural for us to have and carry on a conversation through various interventions. But please, for the purposes of this video conference, please do not interrupt others when speaking. In order for this procedural conference to flow smoothly, I'll ask you to please communicate using verbal cues that you might not otherwise do in in-person meetings. So as with in-person meetings, please introduce all of yourselves and your team members and identify them on the screen. When you finish speaking, please indicate that you have finished speaking, and I have, for example, say, I have concluded my argument so that I can pass the speaking baton to the next speaker. When you're thinking about these communication cues, think about them in the way of a baton. So you are passing the baton to the next speaker. And under these circumstances, in terms of the tribunal's engagement, we will try not to intervene until the speaker is finished. So we will try not to, we will refrain from asking questions to the extent that we can. However, if we do choose to ask questions, we will raise our hand as well, and I will do my best to watch out for this, and if necessary, interrupt to get the speaker's attention. So unless there are any other questions at this point, we can now proceed. Claimant, have you and respondent agreed upon the order of play for today?
Yes, thank you, Mr. Arbitrator. The parties have agreed upon on the facts and the issues to be decided by the tribunal, but we have not discussed the order of this argument.
Thank you, Mr. Han. Respondents, do you have any comments on this?
Claimant is correct that we have not agreed to the order of today's session, but respondent suggests that we exchange the arguments on 3 topics. First, governing law. Second, bifurcation and video conferencing. And third, document production.
Thank you, Mr. Lee. And Mr. Han, do you have any comments on respondent's proposal?
Thank you, Ms. Arbitrator. We have no comments to respondent proposal.
Okay, unless my co-arbitrators, Mr. Walsh or Professor Kim, have any comments, I propose that we move forward in this manner as agreed upon by the parties. So claimants, please.
Yes, thank you, Ms. Arbitrator. So the claimant submits first about the issue of governing law. With respect to the governing law of the contract, claimant submits that Korean law shall be the governing law of this arbitration without application of CISG for the following reasons. First, despite respondents' disagreement on the governing law of this contract, there is no ambiguity regarding the governing law clause of this contract. The words used in the contract are clear and therefore must be given their ordinary meaning. Regardless of which law governs the issue of interpreting the governing law clause, the contract clearly sets out Korean law as the governing law and makes no reference to CISG. Second, although CISG was discussed as one of the options for the governing law of the contract, the parties have agreed that only Korean law shall govern the contract. Please allow one moment so that I can take you to the KCAB rules. As you can see from the slide, Article 29 of the KCAB rules provides that the tribunal shall take into account the provisions of the contract and relevant trade usage. In this regard, the parties have engaged in international business and trade for many years, and of course, knows very well about CISG and its legal implications. If it were a party's intention to apply CISG to the contract, the parties would have made it clear by inserting the reference regarding CISG. In this respect, it should be noted that respondent drafted the contract, not claimant, and claimant just signed it without any changes. As it will come to light by the witness of claimant, after having intense discussion about the application of CISG, the parties decided to exclude CISG as the governing law. This is why the parties did not add the reference to CISG, and respondent's argument based on parties' alleged agreement during the negotiation has no bearing. This concludes my submission on the governing law. Thank you.
Thank you, Mr. Han. Mr. Lee?
Thank you, Madam President. Please excuse us wearing masks. Wearing masks does not mean that we tested positive. We actually tested negative, but to be safe, we are wearing masks because we are sitting in the same room. Let me move on to the governing law argument. It is undisputed that Korean law governs the contract. Claimant.
Mr. Lee, can I interrupt you for 1 second and ask you to please speak more slowly, because it's hard for us to hear you with the mask on, which I understand you should wear, but if you could speak slowly. Thank you.
Yes, madam. Will do. Claimant is correct that Korean law governs the contract. Respondent's position is that CISG applies to this dispute as special law because CISG is incorporated into Korean law, and CISG applies to international sales of goods contracts, and the contract at issue in this arbitration is sales of goods contract. On all these 3 points, claimant does not disagree. Therefore, in principle, CISG should apply to this contract. Again, claimant does not appear to disagree to this principle. Then, this claimant's argument, claimant is saying that parties agreed to opt out the CISG. Respondent disagrees. The contract simply states the governing law is Korean law.
Mr. Kim, can I just confirm with the other members of the tribunal, I'm having difficulties hearing you. I think we've come to the beginning of Chiann's introduction, where she said we needed to be aware of technical issues. Ms. Bao, Professor Kim, can you hear Mr. Kim clearly?
I am also getting static, so I wonder if there are devices near the video conference device.
I'm having problems as well.
Mr. Kim, you might want to roll back, I think, about 30 or 60 seconds because it's been cutting in and out.
Is this okay? I think I have to take it off.
Yes, it's okay for me. Thank you.
You'll have to just ask your co-counsel to move a little bit further away to keep safe.
Okay. So the contract simply states the governing law is Korean law without more. While Article 6 of the CISG provides the possibility of opting out its application, courts have interpreted that there should be expression of intent of the parties to do so. This principle is also undisputed by claimant, and was there in this case an expression of the parties' intent to opt out the CISG application? Claimant argues that the parties agreed verbally to exclude CISG from application. That is not true. Respondent submits that the parties had verbally discussed the matter, but ultimately CISG was not excluded from application. Australia and Korea are both contracting parties to the CISG, and the application of CISG was the basis for the respondent, an Australian company, to enter into the sales contract with claimant. Because precisely CISG is part of Korean law, and CISG is the standard internet. Sorry.
Mr. Kim, I think the static is still continuing despite the mask. May I ask that you remove other devices from your computer, and if you have a set of headphones, perhaps you can try using those. Mr.
Let me
Kim, would you like to
try.
test it again? Yes, thank you.
Is this okay? Thank you. Okay. Sorry for the problem. Let me resume. Because CISG is a part of Korean law, agreeing to the Korean law means that CISG was agreed as the governing law of this contract. That's why the contract does not have the opt-out provision. With this background, claimant tries to lead the tribunal to think that this is a factual issue, whether there was such verbal agreement. It is not. Respondent submits that the matter ultimately rests on the interpretation of the contract. The black letter of the provision of the contract should supersede any other circumstantial factors. Although there is no parole evidence rule in Korea, the principle of contract interpretation is not far from those of many other jurisdictions, which gives the most weight to the language of the contract. In this case, the contract simply provides that Korean law governs without opting out the CISG. Even when we take into consideration of the intention of the parties at the time of contracting, the tribunal will find that CISG was not excluded. There are three undisputed facts here. The draft contract was provided by respondent. The CISG was verbally discussed but the finally executed contract does not contain an opt-out clause. These three facts clearly indicate that the parties agreed not to opt out the CISG provision. That is why this is an issue of contract interpretation, which does not require examination of factual evidence. If the parties' views are different, then the tribunal should look at the contractual language, and the contract says Korean law governs. Therefore, CISG, as part of Korean law, and as the special law applicable to international sales of goods, should be the governing law of the contract. This concludes my submission on the governing law. Thank you.
Thank you very much, Mr. Kim. Now, claimants, can I invite you to address the second question, please?
One question, if I may. I just want to clarify, Mr. Kim, so Austria is also a member of CISG, right?
That's correct, Mr. Kim.
Thank you.
Thank you, Mr. Kim. Claimants Counsel, can you please address the issue on bifurcation?
Yes, yes, thank you, Ms. President. For the second issue, bifurcation, my colleagues, Ms. Hyunyang will address.
Thank you, Ms. Arbitrator. Claimant submits that this arbitral proceedings should be bifurcated so that the tribunal can rule on the issue of governing law first as a preliminary matter. As discussed previously, the parties take different positions in terms of governing law. The claimant submits that the Korean law should apply exclusively, while respondent submits that the CISG should also apply. If there is no clarity on which law applies to this case, the parties will be forced to plead this case under both Korean law and the CISG. Needless to say, it will be highly inefficient in terms of both time and cost. Therefore, in order to run this arbitration proceedings in an expeditious and a cost-effective manner, we suggest that the tribunal to bifurcate the proceedings and make decision on the governing law issue first, so that the parties, as well as the tribunal members, would have clarity on which law applies to this case. Indeed, Article 16.2 of the KCAB rules also provides the grounds for the tribunal to bifurcate the proceedings. If I may take a moment to invite you to take a look at the rules. As you can see under Article 16.2, the arbitral tribunal may, in its discretion, bifurcate the proceedings and direct the parties to focus their submissions to those issues that could dispose of all or part of the case. Therefore, for the sake of efficiency, we ask the tribunal to bifurcate the proceedings and rule on the issue of governing law first as a preliminary matter. Thank you.
Thank you very much, Ms. Koo. And respondent?
Thank you, Madam President. I just want to make sure, can you hear me all right?
Yes, I can, yeah.
Okay, then I will proceed to address the issue of the bifurcation from the respondent's perspective. The issue of the governing law should not be bifurcated. There is no efficiency gain, actually, as a decision on the governing law issue will not result on disposing of or reducing the scope of the case, and the facts are too intertwined with the facts of the merits of the case. Usually, the two principal grounds for bifurcation in arbitration proceedings are that the issue has an exclusively preliminary character, so that it would save time and cost and thus enhance procedural efficiency by being dealt with first on a preliminary basis. Such an issue would be, for instance, one that is not linked to the merits and that can be decided upon its own. And when decided, has the potential of actually, as claimant has conceded, of disposing of a dispute or significantly reducing its scope, thus saving time and cost. This is also recognized by Article 16.2 of the 2016 KCAB International Arbitration Rules that the claimant has cited. It provides, if we may look at it closer, and I excuse our challenge on technology, could we try, if I may ask the claimant to put up the slide again with the, we'll test the technology and see whether that works. Thank you so much. So if we read closer, Article 16, Paragraph 2 of the KCAB rules, the arbitral tribunal, it says, may, in its discretion, bifurcate the proceedings and direct the parties to focus their submissions to those issues that could dispose of all or part of the case. This provision, by using the word may, is permissive, it's not mandatory, for the tribunal to use its discretion to bifurcate the proceedings indeed. But it is premised on the issue object of bifurcation having the potential of disposing all or part of the case. In such a case, we concede resolution of such issues on a preliminary basis would lead to efficiency and saving and would make sense. However, if there is an efficiency gain and a separate phase would only lengthen the proceedings and result in increased cost, then bifurcation should be denied. It is the submission of the respondent that we are on this latter case, and there is no procedural efficiency that would be gained by bifurcation. The case will not be disposed of or reduced in the scope by any decision on the governing law. All of the disputed issues shall still be pleaded, and the parties' potential efforts in arguing their respective positions under Korean law, including the application of the CISG, does not outweigh or justify the additional time and cost that bifurcation would entail in this particular case. As my colleague explained already, the issue of governing law is a legal issue of contract interpretation. Therefore, the tribunal was to consider the witness examination would be necessary to decide on the issue of the governing law. This would further support the respondent's position that the issue should not be bifurcated, given that the facts are too intertwined with the merits of the case. The same witnesses that testified for one, that would have to testify for one issue would have to testify for other issues related to the merits of the contract, on contract negotiation that entails other aspects of the merits as well as the implementation of the contract. Therefore, the respondent is of the position that there should be only a merits hearing in this case, and given that there is no procedural efficiency gained by bifurcation, witnesses shall only testify at the merits hearing with respect to the governing law also as necessary. And this concludes my submission on the issue. Thank you so much.
Thank you very much, Ms. Lee. And we have our final issue then. Claimants. Oh, Mr. Kim?
If I could just interrupt with one question for the parties. How many witnesses do the parties anticipate will have to be examined?
So, if I may, the claimant submits that we expect maximum 2 witnesses to testify about the facts and negotiations the parties had in terms of the contract. Thank you.
Respondent expects that we will have only 1 fact witness. Thank you.
Thank you.
That's helpful. That's helpful. Thank you. Now we have one remaining question issue. And Claimants Counsel, can you please proceed?
Yes, thank you, Mr. Arbitrator. So I'm going to address the last issue, which is about document production. As the tribunal and the parties are well aware of, the underlying facts of this case is not simple. As discussed previously, the parties are in dispute of the facts regarding the governing law. Further, respondent alleges that it had failed to deliver the product due to the pandemic, but this is not the case. Claimant submits that respondent's failure to deliver the product is due to respondent's poor performance to manufacture the products in time, not because of the pandemic. While respondent argues that it is not responsible for the failure to deliver the products, we believe this is clearly a breach of the contract by respondent, which respondent is responsible for. As documents which will shed light on these disputed facts and issues are not in the possession of claimant, claimant submit that it is essential to be given the opportunity of comprehensive document production. In this regard, respondent appears to argue that the PRA rules should apply instead of IBA rules. However, we understand that one of the key differences between PRA rules and IBA rules is that PRA rules follow the civil law style by limiting the scope of document production. We believe this is highly unreasonable for several reasons. First, this case requires an extensive document production given that the key issues in dispute relies heavily on facts. As such, claimant submits that PRA rules, which is intended to limit the scope of document production, is inappropriate, and applying PRA rules instead of IBA rules would be particularly unfair for the claimant. This is because most of the documents which would show why respondent failed to deliver the products are in respondent possession. Second, respondent appears to argue that the PRA rules should apply given that both parties are from civil law jurisdiction. But respondent's such argument has no bearing, especially given that respondent is represented by a counsel having huge experience in arbitration. Further, most of the cases, if not all, respondent counsel have conducted must have been governed by the IBA rules rather than PRA rules. We also note that all of the tribunal members have common law background. Third, respondent opposed to IBA rules based on its argument that the standard of narrow and specific document request under the IBA rules is too broad and vague. Please allow one moment for the slide. As you can see, Article 3 of IBA rules provides that a request to produce shall contain a description in sufficient detail of narrow and specific category of document. The issue of whether a document production request meets the standard of narrow and specific is an issue for the parties to plead at the document production stage and for the tribunal to rule on thereafter. This is clearly a substantive issue, not a procedural matter to be addressed at this CMC. Further, the IBA rules is a renowned standard used as a guideline in international arbitration. There are numerous books and commentaries which set forth what narrow and specific document request means. For example, one of the commentaries of the IBA rules provides that the IBA rules simply requires the description be sufficient to identify the document. In other words, the narrow and specific standard has already been well established in international arbitration. The interpretation of such standard is up to the tribunal's discretion based on the subject matter and nature of the claims and defense. Therefore, respondents position that the IBA rules should not be used unless there is a clear understanding of narrow and specific standard has no bearing. This concludes my submission. Thank you.
Thank you, Mr. Han. And Respondents Council.
Thank you, Madam President. When claimant argues that the IBA evidence rules should guide the document production, it emphasizes that the document production is necessary and important to Mr. Walsh.
Mr. Kim, I think we're all getting static again. I'm afraid your colleague may have to disappear off screen for the moment, if that's okay.
Okay. Do I sound okay now? Thank you. So the claimant appears to agree that applicable rules should be determined.
Mr. Kim, I'm not sure what you managed to do before, but we're getting the static again.
I'm wondering if maybe if Mr. Kim, you move your position, maybe that might change things.
Can you hear me? Can you hear me?
Yes,
Okay.
let's try again.
What? Okay. So claimant appears to agree that the applicable rules for document production should be determined by how much document production will be critical in this arbitration. In other words, the standard should be how much claimants need to rely on documents that are in possession, custody, control of respondent. If documents currently at claimant's hand are enough to prove his claim, or if the documents currently at respondent's hand are enough to defend respondent's defense, establish the respondent's defense, document production will not be necessary. This case entails a simple and straightforward contract for sale of goods. This is not a dispute related to complex transactions such as project finance or construction or post-M&A dispute. The facts of the case are also straightforward. The parties do not dispute that the respondent committed to deliver certain products and that it failed to do so by the agreed upon date. The respondent's case is that it is, however, exempt from the liability for such delay. The ongoing COVID-19 pandemic has created impediments beyond the respondent's control, which excuses respondent's delay under the CISG. The respondent intends to deliver the products as soon as possible in the circumstances when the COVID-19 pandemic situation has been lifted. Claimant is not denying the existence of COVID-19 pandemic, which is why we are doing this hearing by video. Claimant is also not denying that the pandemic made the shipment impossible. Claimant's case seems to be that even without the pandemic, respondents would not have been able to deliver the product by due date. However, it is the respondent who has the burden of proving the force majeure event that impeded respondents' timely compliance. If respondents fails to prove that the delay was caused by the pandemic, but not from other causes, respondent's force majeure defense will fail. Therefore, there is no need why claimant should require production of documents from respondent in this case. It is rather suspicious to the respondent that claimant, who is also in the same industry, is pushing in this case for document production that it would not benefit from in its home jurisdiction. Moreover, as claimant noted, both parties are from civil law jurisdictions where pre-trial discovery or document production are not the usual practice. There is no reason to deviate from the usual practice in their home jurisdiction in this case. The relevance and materiality tests under the IBA rules are yet too broad in practice and create great burden and increased cost and delay in the proceedings, given the simplicity of the case and the amount of the case. In contrast, the 2018 Prague rules better reflect the rules applicable to the practice of evidence in civil law jurisdictions. Thus, the respondent submits that they are better suited for this arbitration than IBA rules. The respondent advocates for expedited, efficient proceedings. In this vein, the respondent's position is that this arbitration should not deviate from that standard, resulting in the proceedings being more costly and burdensome to the parties. This concludes my submission. Thank you for the attention.
Thank you very much. My co-arbitrators, do you have any questions?
From myself, no. Thank you very much to the council for the clear submissions.
Just one issue that I wanted to flag. I noticed, if I'm correct, the claimants are pushing for a video conference, the bifurcation to be by video conference, and the respondents would prefer to have it in one hearing later on at the end. And we are talking about 3 witnesses. And I guess one kind of practical question would be, how many of these witnesses would be more seasoned witnesses as opposed to less seasoned witnesses in terms of their age?
Yes, thank you, Mr. Arbitrator, for your question. So we will present 1 or 2 very seasoned witnesses who have engaged in negotiation and contract execution with the respondent, and also they have like huge experience in those kind of work. We believe that there will be no difficulties or hazard, so that they can testify and address the issue and how the contract has been finalized with the respondent. Thank you.
Can I ask one further follow-on question to Mr. Han? Do these witnesses require translation? And if so, how do you envisage that would be done through video conferencing?
Yes, thank you, Mr. Arbitrator, for your question. Because those are Korean employees, their English is just good enough to have engaged in contract negotiation with the respondent, but they will require an interpreter for the preliminary hearing for their testimony. But how we can secure how we can secure that their testimony will be independent despite having it done through video conference? My colleagues, Ms. Hyunyang, can address and how we can secure those issues and concerns. Thank you.
Just to clarify, the reason I raised the age issue actually was because given the current pandemic situation, I would think that more elderly witnesses could pose a greater risk for them to travel, and therefore made more sense to hold it by video conference. That's actually what I was curious about. Thanks for the clarification.
Thank you for your question, and I'm sorry for not being more clear on the point. So we propose to have a video conference even for the witness testimony. So like I said, my colleague Ms. Chiann will address this point, how we can secure.
Mr. Han, you have an echo to your voice now.
Thank you. So I was going to say that my colleague, Ms. Hyunyang, can address how we can secure the concerns and the some kind of potential issues about doing a virtual or video hearing about witness testimony. Thank you.
Thank you, members of the tribunal. I would like to briefly discuss the issue of the video conferencing and how to secure a stable environment. As some of you may be aware of, the Seoul Protocol on Video Conferencing in international arbitration was launched a few weeks ago. It provides clear standards and requirements in terms of logistical as well as technical, in terms of how to implement a safe and stable environment of video conferencing. And as the issue of involving the translator, it also provides how to involve the translator while the witnesses are providing his testimony. And I would like to just briefly show you my screen, if you would allow me one moment. And just to add, we believe that this is one of the advantages of using video conferencing in hearing. We would not have to trouble you to go through all the heavy hearing bundles. As you can see, the SOL protocol provides different aspects and clear standard of how to fairly secure the proceedings of arbitration hearing through video conferencing. For example, there could be issues regarding witnesses being provided with unlawful assistance. It provides under Article 3.1 that the persons who should be present in the remote venue while the witnesses are providing its evidence includes the representatives from each party's legal team. We do not believe that it has to be someone from the legal team. It could be any representative or even parties' counsel. As long as there is someone there, we believe that such issues can be dealt with. And the SOL protocol also provides technical specification in order to conduct the hearing in a stable environment. So we believe that adopting the SOL protocol once the tribunal decides to conduct bifurcated proceedings and conduct the hearing through video conferencing is definitely a viable option. Thank you.
Thank you. Unless the parties have any other comments, or the co-arbitrators, do you have any other comments? Oh, Ms. Lee?
Yes, thank you, Madam Chairwoman, Madam President. We would like an opportunity to respond on this issue of the examination of witnesses by video conference.
Yes, please.
So the respondent's position, we oppose strictly to the examination of respondent's witness by video conferencing. In particular, in response also of Professor Kim's question, the respondent's witness is of certain advanced age, and there is the health risk, but on the other hand, he is a little bit traditional in his dealings, let's put it simply. He is not very comfortable with the modern means of technology. And regardless of certain undeniable benefits that these means of technology bring along, he's absolutely adverse. And given the current travel restrictions, he's in Austria, he's unable to travel, his counsel team is here in Seoul, and we're unable to travel to him. And this seriously restricts the preparation of his witness testimony and also the actual cross-examination of the witness. Therefore, coupled with his normal aversion to use of technology, the situation of him being examined by video conference would seriously hinder and unreasonably prejudice the respondent's opportunity to present his case. And this would be contrary to Article 16(1) of the KCAB rules that provides that the tribunal may conduct arbitration in any manner it considers appropriate, provided that the parties are given fair opportunity to present its case at appropriate stages of the proceedings. And given that the place of arbitration is Seoul, the Korean Arbitration Act also in Article 19 provides the same, that each party shall be given a full opportunity to present its case. So in this particular circumstances, in this particular case, despite all the advantages of a video conferencing, and this being just a procedural hearing and the difference from an evidence and merits hearing where the witnesses would be cross-examined and there would be interpretation and all this. I apologize, it's very hard to breathe with this while speaking. That it will seriously hinder the possibility of the respondent to present its case. Therefore, in this particular circumstance, we submit that video conference should not be allowed. And there is also the if I'm allowed to make one additional comment, the respondent's witness is very dubious about the security that is offered by the modern means of technology. We all are aware that Zoom that we're currently using has been is being currently sued in a class action for data privacy and protection issues. And there has been issues also with other means of technology such as Skype. And we know that although there are advantages of using means of technology, if we look at today's article at the Global Arbitration Review, there are still limitations of the means of technology. For instance, Zoom does not offer a breakout room, and there are other limitations. Therefore, we submit respectfully to the tribunal to consider the issue. That closes my submission on the issue. Thank you.
Thank you, parties, for your submissions. I think unless Mr. Kim or Mr. Walsh, you have any other comments, I think we can conclude this portion of the event, the mock procedural conference. Yes? Great, thank you very much. Should I pass it back to Sue? Or is it Robert?
Hi, I'm back. So it's going to be me and Robert and David, but I'll start off with the Q&A session. We have very, very interesting questions, and I can tell people were paying attention as opposed to doing something else. So I have about 10, 11 questions. Some of them overlap. Some of them are exclusively on the technology side of it, which is just as relevant. And I'll be calling out the names of the people who raised those questions, and I'll explain the question, and I'll direct these questions to one of the panelists. But of course, the panelist who has been asked to answer the question may pass that on to someone else if they feel that the other person is in a better position to respond. So just in order of when the questions appeared, I will start off with a question from an anonymous attendee. And the question is the fact that is the virtual hearing and the giving of the award through the virtual hearing have the same effect as that of doing it procedurally? I think procedurally meaning doing it in the more traditional way of the hearing. And I think this question goes to the effect of the CMC and the procedure order through video conferencing. So maybe Tom, would you like to take that question?
Yeah, I think it's a really interesting one. And actually there was an article, and I sound like I'm promoting Clifford Chance now, but I'm not, published by one of my colleagues called Andrew Fu, which I actually read because I found it quite interesting. And I don't normally read my colleagues' articles. But it was talking about that you kind of got to go back to basics when you're thinking about virtual arbitration. And the key question is enforceability. So I think on its own, a virtual hearing doesn't immediately give rise to issues of enforceability, but it really depends on where you are under the applicable national arbitration law and what the rules say and whether there's space for it. And the position for each seat and each set of rules is different. And of course, it probably only becomes an issue if the point is taken by the other side. So where that leaves you is it's quite complicated. And any tribunal will need to look at the national arbitration law, and it will need to look at the procedural rules, and then it will need to make a judgment call on whether hearings can be held virtually. Now, the award itself is a separate thing. It's not the fact that the award or the ruling is given in writing afterwards, which causes the enforcement issue. It's whether just the pure fact that you have a virtual hearing can be argued to not give a party the ability to present their case. I think largely people are going to deal with this quite robustly. But it may be that if one party kicks up a really significant fight and points out the lack of explicit permission in various rules, I think ICC, for instance, is one, it may be concerning for a tribunal to hold a hearing because it may give rise to enforcement concerns. Sorry, as Chiann said, I should pass the baton back now to Sue.
Okay, well, I've got the baton back. Thank you. Does anyone else in the panel have something to add to that? Or I'll just leave that as a thought.
Therefore, I think as Tom just pointed out, I would think it'd be very wise practice for the tribunal to make sure that they've achieved or obtained consent from the parties.
Mm-hmm. Right. Thank you for that. All right. So if I may, I'll move on to the second question that I've seen on the list. And this is a question from Mark's Ikoge, and it's in regards to whether the chair should be the host of the Zoom conference and have control of the muting or unmuting or video of the participants. And there was a similar question from Mark Goodrich to the effect that the question asked whether the chair is having all the technical support in maneuvering through the hearing. I think maybe this could be a question that Chiann, would you like to take a stab at it?
Sure, thank you, Sue. I have to say, having been chair and trying to operate just the mute button itself, I think was a chore. And so the short answer to your question is I think the chair should not be the host. I think there are a lot of technical issues that happen behind the scenes. And perhaps one quick way to resolve this would be to have a host sitting either at the institution or somewhere else, a third party, dealing with any of the technical issues and the host issues. Someone who's obviously familiar with arbitration proceedings, of course, and the flow of the proceedings. But I would say it would be very challenging for the chair to both deal with the technical issues and also digest the information being advocated.
Mm-hmm. Right. All right. So Chiann, probably being the person who played the role of chair, probably feels the issue more than anyone else. But if maybe Professor Kim or Tom, you might have any suggestions?
No, I do think having a tribunal secretary potentially in the same room as one of the tribunal members doing the admin would help. You may have seen some of us reaching towards the screen at points. It's because we had a breakout chat. So you can replicate a lot of the things you see in person. But look, I still think it's a learning curve. Next time, to avoid it look as though I was attacking people, I'd probably have one computer for a breakout chat and one computer for the Zoom conference. But I definitely would suggest members of the tribunal are not kind of dealing with the IT issues.
Okay. All right. Thanks for that.
If I may.
Sure.
This is David speaking, Sue. I just wanted to add that as we've seen for a number of reasons, technological challenges in audio or otherwise, and logistically, as Chiann has explained, you've got to speak slowly. You need to have speaking discipline and pass the baton. There are many ways in which these proceedings are going to go slower than they would go if they were live. And I think that having the chair in particular tasked also with managing the technical administration of it is really going to add an additional level of delay to the process, which is already going slowly. So again, for that reason as well, probably not wise.
Okay. All right. So if I can move on to the next issue, and this is quite a very interesting issue, and I think Hyunjung, you addressed it as you were advocating against the idea of going on a virtual hearing. And this is the question that was initially raised by Maxi Shuri. It relates to the cybersecurity issue. And I think the question goes, if I can find the question out again. Sorry about that.
I can read the question.
I've
got it here.
I'm sorry, I just found it. Yeah. Have the parties in arbitration or the organizers of the moot consider questions of confidentiality and cybersecurity when they agreed to hold the hearing via Zoom. And there were a couple of other people who raised very similar questions about cybersecurity. I think this is a question that everybody here in the panel might have something to say. Well, for the organizing part, we knew this wasn't like a real case, and it was more for the education of the the wider public. But of course, Zoom's or the other platforms, a cybersecurity issue is something that we expect people to consider quite seriously. And I don't know how the pieces will fall after people actually start implementing these virtual hearing settings. Would anyone want to say something about it? I think Tom, you said you wanted to say something about this as well.
I sadly find confidentiality quite interesting in arbitration, because some people seem to treat it as an afterthought, but I think it really is one of the great important things about arbitration, especially as we move to a world of more tech and patent and IP litigation. And I think the short answer is Zoom is not fit for purpose on a confidentiality issue. And that it probably shouldn't be used yet for a proper procedural hearing due to the issues which are being identified in the press. But it is quite interesting in arbitration, a lot of us deal with it, that you have products which are quite weak on confidentiality that people still use. A lot of prominent arbitrators use Gmail accounts. You know, all of that data is read by Google. So I think generally in arbitration, we actually don't treat confidentiality seriously enough. I think Zoom will be the next iteration of that. So I think my view is you shouldn't use it for a hearing yet, despite being part of this test. And we're still on a learning process. We should look at Microsoft Teams and other options.
Mm-hmm. Right. Would anyone of the panelists have? David?
Just to add to that, when we first formulated this idea, that sort of public knowledge of the security issues with Zoom had not come to light, and Zoom was getting a lot of attention, so we thought it would be good to give it a go and let people see Zoom in action. It then came out that there were security and privacy issues, which we took into account, had a discussion whether to shift to another platform that we felt would be more secure, and simply because notices had already gone out and this was purely for public consumption, there's no need to switch to another platform. But I think this is also, as Tom suggested, a moving target. Zoom has gotten a lot of attention, and it's going to be probably trying to address these issues and may resolve them.
I would just add that Zoom, within the last 24 hours, has put out a new version of the software, and I did an update that now prompts you. So I don't know the extent to which people were not enabling the security that was available. I mean, another question that I would have is whether by adding a VPN, if everybody's connecting through a VPN, if that solves the issue.
All right, well, that's a very important, I'm sorry, Chiann.
I was just going to echo David's points and also Robert's, but I think that, I think the point of cybersecurity is real and imminent and something that will make us resistant to using this technology. But during this period of COVID where nothing is working, I think certainly the technology will be ever moving, and we shouldn't discount the use of video conferencing because of cybersecurity. I do think in short time we will improve, and so I encourage everyone to continue testing this out, whether it be through Zoom or other programs. I don't think that that is prohibitive. As David said, it is a moving target, so I think we should all continue to learn how to use this type of technology.
Mm-hmm.
If I may, I want to thank Maxie for her excellent question, but to give this a little bit more perspective, of course, email by itself is inherently very insecure. And of course, it's very common these days for all of us to use cloud services, which probably has far more information that you can gather than through a video conference. So I think it's just over time, I think the security issue, I would hope, and I think will get resolved.
I just want to plug that we do hope that this will be the first of a number of online events in which hopefully we can explore different tools and take a look at which might be more suitable or less suitable, have better functionality, and in particular better security. So hopefully we'll be able to look at that, watch the tech news that comes out, and see what platforms might offer the best security side and give those platforms a try as well.
Right.
Tuned.
Yeah. Yes, stay tuned. That's right. And it definitely is a serious issue that we should all be watching out. Be watching out. Just to move on to the next issue. The next set of questions I have relate to video conferencing of witnesses. One of the questions, and I believe this is the one that came from Ricardo Onkiko, about what's the possibility of witness coaching if you have the witness only on camera and not in real life. I think Hyunyang and Hyunjung also mentioned the SOUL protocol, which is a effort by partly by KCAB International to outline a set of guidelines that would be conducive to a fair but efficient video conferencing of witnesses. But of course, it's not a total answer to the issues of examining a witness through video conferencing. Maybe I should ask Hyunyang or Hyunjung, either one of them, their ideas about what would be, as counsel, what would be a best way to conduct video conferencing through video, or if your personal thought is video conferencing of a witness wouldn't work from the beginning.
If I may, as I have discussed during while I was giving my submission, I found a very helpful article in the SOUL protocol, which I've popped up in the screen, which is to have an observer from each side while the witness is giving its testimony. And I thought it was a good idea, a practical one, in order to prevent those concerns which the audience has just raised in terms of unlawful assistance being provided while it's giving its testimony. Thank you.
Right. Junu?
Alternative to having observers in the same room with the witness would be having two screens. One is close to the witness, one is very remote, far behind, showing the entire room, so that anything else is not there.
Mm-hmm. Yeah, that's a good idea. Maybe that should be an addendum to the SOUL protocol. Yes, Sanghoon.
So, I mean, I have thought about the idea of having two cameras, one to face and one from like a far, away, so that the camera can see like a whole room, and to make sure whether there is any kind of, just person who is coaching the witness during the testimony. But the thing is, the witness can use like, chatting kind of application during the testimony, and can chat with their counselor, with some of the party, and still get coached during the testimony. So I think just having like multiple cameras does not solve the problem, but we should figure out another way to resolve these security issues and to prohibit unlawful assistance.
Mm-hmm. Right. And also, I think it was mentioned by one of the panelists before, if we're in a situation where we're in total lockdown and we don't have the luxury of having technical assistance of this remote witness, of having a short shot and a close-up shot and a long shot, and or moderator or audit, that might restrict all these safeguards that we're thinking of in order to secure the integrity of the witness conferencing. So that's really a situation that I don't know if we have a very practical solution yet, but it might be a real life problem, and we might have to think more about solving that issue as well. Yes, David.
I just want to mention that we've got about 10 minutes before 6. And we're supposed to break by 6 because there's another Zoom event in town. So for the remaining questions, maybe we can pick some of the most intriguing ones and get some focused answers.
Mm-hmm. Right. I'll probably have to check the Q&A scroll that I've closed. Oops, technical issue from my side. I can't open the Q&A scroll anymore.
Some people were asking, and I think everybody was interested, Junu, about what was the problem with the audio and how did you fix it? Because that's a critical issue and very technical.
I'm afraid I didn't follow Chiann's instruction that any other devices should not be near the Zoom equipment. I'm sorry.
No, but then we are in a conference room here, and there was some overlapping between the sound of the laptop and the sound of the audio system. So once we turn off one of them properly, then I think some of the static problem was fixed.
Interference. Okay. Professor Kim, I noticed you also had some popping that I heard. You were very audible, but there was something happening. Did you have it? Were you aware of that?
I turned off my popcorn machine.
I hope you got it with butter. Back to Sue.
Oh, okay, right. So I've been reminded that we are running close to the end of the session. Before anything, I'd like to apologize for the participants. We would love to open the whole floor so people can come in and exchange and voice their views at any time. I feel that having to mute and unmute and give only a certain people the right the voice, it's a bit restricting, and it really makes me miss the real seminars that we have. But with that, I thought this discussion was wonderful. I think that these questions are real and it might pop up anytime soon, especially when we are still conducting our active legal careers as arbitrators or counsels or people in the institution. So I think this has been wonderful. I think I was supposed to give Robert the chance to give the closing remark, so maybe I should do that. Robert, would you like to close the session? Robert, I can't hear you.
Yeah, I'd like to thank everybody who called in today. This was truly an international event. I just jotted down some of the cities who were dialing in. We had people from Barcelona, Dusseldorf, Ho Chi Minh, from Moscow, from New York, from Paris, London, Mumbai, Lima, Singapore, Hong Kong, KL, New Delhi, Istanbul, Tokyo, and Bangalore. That's just some of the participants. We had people on all continents except Antarctica. I think that this is a fascinating new technology. In arbitration, we've been talking about using technology more, and I think that this virus is going to give us an incentive to come up the learning curve very quickly. Today was an experiment. We didn't expect everything to go entirely perfectly smoothly, and it didn't. But the question is, were we able to work through those issues? And I think that we were. What would we learn, next time? I think that the headsets are good for the sound. I don't have a proper green screen yet, but as we've been experimenting with the virtual backgrounds, I think that I would want to have a green screen before using too many of these in the future. And I think that you can see everybody's lighting is a little bit different, and how they are able to communicate through a screen. It has an effect on that. So it's certainly a medium that I'd be curious in experimenting with. And I think that it's something that we can only get better at through practice. And I'm looking forward to practicing again in the future. I'm sure that KCAB and KCAB Next will be doing more events like this in the future, maybe through Zoom, maybe through other media that are available. I would like to thank all of the participants today, the tribunal for their fantastic questions, for the council teams for putting together the problem on short notice and for being so prepared. So thank you very much. Thanks everybody who's dialed in, and we look forward to seeing you at the next KCAB Next event. Thank you.
And for those who have asked, the video recording of this event is supposed to have been taken and will be made available on the KCAB website, we understand. Thank you.
Okay. Thanks everyone. Goodbye.
All right, everyone.
Thank
you.
you.
See you. Bye-bye.
Thank you.
Bye.